alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
The
it
security feature entirely?
in the audit trail? You also
No, the audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question:
Yes.
How does the redeeming branch?
Yes.
How does the redeeming branch
Yes.
match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it, the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
There's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's
the
alphanumeric. Yeah.
But cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think Mr. Bhushan should hold his peace for a minute.
Fourth, what is the information that you see when you scan the alphanumeric?
But you see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No. That's what I'm saying. That correlation was not kept for the reason it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done. Their bank account details, etc., etc. Everything is done. That is silo 1, if I so call it, which is nothing near Rochester. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in the. We next get to see the bond when somebody comes and says.
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
But not even in the final judgment.
Say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
But your lordships,
all details.
That's why we came to
Mr. Salve will clarify to put it beyond any.
No problem at all.
We will say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed any, you will not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains.
Details, you have to disclose all details. Let them know, because the burden should not lie upon the court or the petitioners to say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
Yes, we'll do it, Malad. There's no problem. Just that this constant, the media constant beating down and the petitioners giving public interviews saying, we will take the state bank to task and we will show this and we will haul them up for contempt, etc., etc. But we are also public institutions working in this space. And it's all right. People work, people acted on the faith of this. Your lordships granted an interim order saying keep records. It wasn't at that time, Malad, subject to correction. I didn't find any order which says all further actions will be subject to the judgment or something. There was no such direction. Your lordships are at that balancing interim order. Now, whether completely you should lift the privacy or remove anonymity, better your lordships will.
Mr. Salve, the idea behind the interim order was in case the writ petition is allowed, then data should come out. And that's what exactly is required. Nothing more.
I must say so, Malad, as out of whatever, as Malad, the Chief Justice is saying, your lordship will clarify. We will give every bit of information, relevant, not relevant. We'll give every bit of information which we have. So that, Malad, there should be no feeling that SBI is interested in somehow holding something back. I only want, Malad, to share one thing. Malad, your lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing the lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know, which is absolutely, and my lord say, give the bond number, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so-and-so, investigate so-and-so. That is, I don't think, the purpose of your Lordship's judgment. That was not what it was meant for. And your Lordship will see whatever safeguards need to be put in place.
Just one more
Lord,
thing.
I have 2 minutes, my Lord, if your Lordship permits.
Yeah.
At the outset, my Lord, on behalf of the central government, I completely disassociate myself with what Dr. Agarwala has written. It is completely unwarranted and ill-advised. I want that to be made very clear, my Lord, on behalf of the central government. Now, my Lord, I have something to share, and I have been watching this very painfully, my Lord, outside the court. My Lord, your Lordships sit in kind of a silos. Your Lordships are, my Lord, in an ivory tower, not, my Lord, in a negative sense of the term. But what we know here, my Lord, your Lordships never come to know. The way in which your Lordship's judgment is playing out, my Lord, something your Lordships must, my Lord, be informed as highest court of the country. But what has happened? My Lord, our case was that we want to curb the black money. A criminal may have paid the donation, but ultimately the donation comes in the white economy, and we could not persuade your Lordships. Lord, your Lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your Lordship wants is not, my Lord, kind of a witch hunting. Earlier, my Lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my Lord, the witch hunting has started, my Lord, at some other level, my Lord, not at the governmental level. The application comes of the SBI before your Lordships on 11th of this month, my Lord, and your Lordships also, my Lord. That's how, my Lord, we understood, clarified the position. But most serious things, my Lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my Lord, and there is, Lord, a non-level playing field, my Lord. On this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my Lord, a series, a barrage of social media posts, my Lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my Lord, now it's anybody's field. It's an open field. Lord, statistics, your Lordships are aware, can be twisted in any manner the person wants. It's a matter of, my Lord, intelligence of the reader to understand. Now, my Lord, based upon the twisted and other statistics, Lord, any kind of posts are being made. I know, my Lord, your Lordships cannot control them. But the question is, would your Lordships, my Lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control? Lord, that saying Mr. Rodgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of Para 221.
That's
as judges, we decide according to the Constitution.
correct, my Lord.
We are governed by the rule of law. We are also the subject matter of comment on the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm not, my Lord, for a second.
Our court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
Lord, my purpose is to inform your Lordships that there is something else playing out which neither your Lordships intended nor the scheme intended. And, my Lord, kindly bear that fact in mind. On 11th of March, my Lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My Lord, thereafter, this started in a very systemic.
Already. Order.
Just one fact.
Can I assist you?
No, Mr. Rodgi, we don't need assistance right now at the conclusion of the matter.
One fact. One fact.
I am the person who's going to.
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Rodgi, we'll not hear you when your application. We have to follow procedure in the court. It's a constitutional court.
One
Will allow us.
Mr. Rodgi,
Yes,
no,
something.
Mr. Rodgi. I told you the reason for it. We are now at a stage when the
I
judgment.
am not on my application, not that critical infrastructure. I am now only saying.
No, Mr. Rodgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. You don't need any third party.
Your Lordship didn't get a proper assistance.
So just one
The
thing.
grievance of those who will now be deemed that who have A party, who have given to B party, that will
That
be.
was precisely the answer. That was.
Lord, one more clarification.
What we gave to the government under a scheme.
Mr. Rodgi, there's only one simple answer.
Yes.
With effect from the 12th of April 2019, when we directed the collection of all details, everybody was put on notice that hereafter, the details which you furnished would be subject to the result of the petition.
No problem in
Therefore, in drawing the balance, we did not ask for the disclosure of details prior to the interim order of the court. And
Absolutely.
that was a very conscious and well thought out decision of the Constitution bench.
Was it the intention of the court to know which man paid where, so that if he pays A party, he will be subject to victimization?
Answer is yes. Answer is.
The answer is yes.
Lord, only one line, my lord, only one line, my lord. Mr. Bhushan may, my lord, now hold his horse.
Pursuant to your.
Yes, done, my lord, substantial assistance. I don't have to formally disassociate myself with today's mentioning. my lord. That I disassociating from Mr. Agarwal doesn't mean that I am.
Mr. Solicitor, irrespective of the
Yes, my lord. Yeah,
we,
but maybe treat it as.
we must just tell you that we respect this very responsible approach which the Solicitor General has adopted of, because, clients apart, who you are representing apart. The
It is
institution has
really
to stand
painful,
above
my
it.
lord, when the people
So-
before the court start, my lord,
Thank
a
you
media
for-
campaign
thank you for
to
saying that.
embarrass the judges.
Thank you for
It-
saying that you
it's
don't
very, my lord,
associate with the mentioning. Thank you for saying that you don't associate.
Because
with the
there is no level playing field. I can't hold a press conference.
Only grievance is that it was not a justiciable issue. Yeah, Solicitor General did not raise it. It is not a matter of pure policy. I read the entire judgment. It was entirely a policy issue. It is not justiciable at all. That's all I want to say. The people of this country feel that a decision was taken behind their back. When the parliament decides, they were present in the parliament. It is with their consent. When your lordship decides, we are.
Last order, the election commission has put out the sealed covers but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
You don't have to go into
No,
all
but
that,
because-
Mr. That's
because-
not our remit at all.
No, I
Yes, what has happened after the judgment is not something we are concerned
Not
with
after
at
the
all.
judgment. What I'm saying,
Now,
no, what I'm saying is this, that since the order of the,
very recently, I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. It's the property of the nation. And
no, I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the election commission, only a few of the political parties, the smaller regional political parties, some of them have disclosed.
He is not
the names of
addressing
the
your
donors.
lordships, he is addressing somewhere else.
The-
Kindly hear him for some time.
Correct?
So that it
It's
comes, my lord, in the
amazing,
newspaper
amazing.
tomorrow, that
The-
Mr. Prashant Bhushan
Amazing,
vehemently said this. That's
amazing.
the purpose.
I'm
Solicitor,
pointing out
unfortunately,
something-
public interest litigation have now become publicity interest litigation.
It is
Absolutely.
publicity interest litigation.
I
It
am
is, my lord,
pointing
there
out
are some hidden agendas. There
something.
is no doubt, my lord, and I am not, my lord, apologetic in saying.
I'm astonished.
And my lord, that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately.
Lordships, in your lordship's majesty,
So what
would
I
not
was
know,
pointing-
my lord, what are the hidden agendas behind it.
just dictate a short order. I
I
think,
just
we
point
are
out that
unnecessarily expanding upon
because-
the remit.
Because the major political
Just
parties
listen to the order.
have not disclosed the donor.
Just give us 2 minutes to dictate the
Therefore,
order. We'll-
what all that I'm requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a
One second,
situation.
1 second, we got the point. You filed an application on that. In our order.
They have filed an
Just, Mr. Ansari, just 1 moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes,
Why should we, in our interim order, we said that the disclosure shall be made with effect from the date of the interim order.
Yes.
12th of April 2019.
Yes.
right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitutional Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media, some via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the
So
judgment.
the only reason why I'm saying that,
modify that date.
no, the only reason, because your lordship asked the political parties to give donor details to the Election Commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore, I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties.
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems. A lot of your issues will
But
get
for that period of 2018 till
solved. No, that
April
we are not
29,
sitting in a review. We have taken a conscious decision.
we are
Please
faced
file
with a
review.
situation where the
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
no.
And
In the light of the disclosure which has come to light of the political parties, that's why I'm saying.
it is not a
If the
casus
political
belli.
parties had disclosed the donor details, this would not be required.
Draw the line somewhere. We had to hold the balance. We've held the balance ultimately.
As your
at
lordship
212.
pleases, but I just.
Can I just add one thing? Lordship said all the details. Lordship may consider, my lord. I have pointed out that 6 details may be necessary, my lord. One is the serial number because they say 28,030 bonds have been issued. The second would be the date.
1 second. When you say serial number, you mean the alphanumeric,
Total
right?
number of bonds issued are 28,030. I'm not saying when a lordship said all details, not in my respectful submission, it will be.
Mr. Sarve has been.
No, my lord, lordship, just permit me a minute.
Sarve has fairly stated that he will
No, my lord.
all the details.
No, my
Why?
Yes,
No, my lord, if I can just show.
And date are all already
What your
disclosed.
lordship would say, my lord, I'm just pointing out what details can be there. First is serial number. Second is the date. The third would be alphanumerical number. Fourth column would be name of the donor. Fifth column would be the name of a political party. And sixth column would be the amount. Well, this will cover all the details, not in my respectful submission.
This is now asking us to sit down and collate one.
This
with
is
the
a
other.
submission made to the court. Just like Mr. Salve made a submission to the court. I'm making.
Yeah, we need.
Very well. I'm making a submission to the court. Mr. Salve asking us to do whatever. Look,
Please permit the my lord the Chief Justice to dictate the order now at least.
Secondly, my lord, the lordship said, lordship has seen that IA, my lord. I filed that IA. For a previous order, if a lordship have taken a conscious decision on that aspect of the matter, my lord, lordship may say, my lord, because the order said, my lord, the voters are entitled to know as a right of information. If a lordship have taken a conscious decision on that matter, my lord, it will be from 12th of April only because we said, my lord, it should be, my lord. Otherwise, logically, once the right to know, my lord, is inbuilt in the system, in right to know of the voter. Very well, I'll leave it at that.
And there's a specific direction with effect from 12th April.
Then your lordship said, I have not pressed the application.
So Bhushan, there will be no end to it.
What is the IA number, Mr. Ansari? Just 1 second, Mr. IA number which you are not pressing is IA number?
Diary number 12580-2024. Which is MA number. MA diary number.
So that you're not pressing.
Yes, my lord.
Just
Just
one,
say MA
by way
diary
of
number
information only.
12580-2024. Mr. Vijay Hansaria, Learned Senior Counsel, appearing on behalf of the applicant, states after some submissions at the bar that the miscellaneous application is not pressed.
In view of
one
my lord,
thing.
whatever proceedings have gone to the court, in view of the proceedings before,
Whatever in view of whatever.
Lord, if your lords, you can say that.
Oh,
Otherwise,
in view of what? In view, we'll say, in view of the specific directions contained in paragraph 200, in in paragraph 219, bracket B and C of the judgment of this court dated 15 February 2022.
Just one fact by way of
Not
information.
enough of assistance by this public spirited person, my lord.
The
Your
details,
lordship doesn't need any further assistance.
the details of the number of bonds shown by the, in the data. which
He is
has been
gathering the
submitted,
details for a future PIL, my lord, so
the
that
number of bonds,
remains in,
the
he remains
number of-
relevant.
Now, please permit the, my lord, the chief justice to declare the order.
Heard everybody, Mr.
I was just pointing out that there is a huge mismatch between the number of bonds purchased and the number of bonds encashed in the data submitted by the State Bank to the Election Commission. They are showing 18,871 bonds purchased, but showing 20,421 bonds redeemed. The total amount of bonds purchased is 12,155 crores and the amount redeemed is 12,769 crores. That is 550 crores more than what were purchased. Now, the explanation for this could be because the data is from 12th April. At that time, the bond purchase was going on. On 12th April 2019, it was going on. What is possible is that some of these bonds were purchased prior to 12th April 2019, but redeemed after 12th April 2019, and that is why there is a mismatch. But I just wanted to point out there is a very large mismatch.
There is no, my lord, these figures are not authentic. I've given the authentic
18,000 versus
Those roughly
20,000.
Sponsored
22,000.
NGOs are, my lord, fudging the figures and bringing their own, my lord, your lordships are aware, there is a beautiful, my lord, quotation by Einstein, that some people use statistics like a drunken man uses lamp posts more for support than for illumination.
I'm just showing the number. I'm saying that
And
18,000.
this is what happens
All right,
when
we'll now
it,
leave it at that. I will-
My lord, those numbers are not right, since, my lord, because all this is going to play out, the numbers are not right. The corrected numbers were not given in our application.
वो अलग order pass कर देंगे। इसमें MA में ऐसा लिख लीजिए, in subpara B and C of paragraph 221 of the judgment of this court dated 15 February 2024, the direction to the SBI to submit details of bracket 1, the electoral bonds purchased, semicolon, and bracket T2, political parties which have received contributions through electoral bonds, is specifically since the date of the interim order dated 12 April 2019. Stop. In other words, all details which have been directed to be furnished in the operative directions of this court are with reference to the interim order, are on the basis, don't say on the basis of, are with effect from the date of the interim order, namely 12 April 2019. Full stop. The relief which has been sought in the MA for predating the point of disclosure would amount to a substantive modification of the judgment and hence cannot be dealt with in a miscellaneous application. Full stop. The miscellaneous application is therefore not maintainable and is accordingly dismissed.
But I want one more relief to prevent another round of contempt proceedings. Would your lordship just for a minute have my affidavit in compliance?
What is it that you want clarification?
Yes. Marat, there was, when we gave your lordship, that's why I can see all this story has started. When we gave your lordship the original figure of 22,217 bonds, we had, by mistake, that was from 1st of April, not on 12th of April. If your lordship just sees para 4 and Marat, everything will be over because I know where this is going, where Mr. Bhushan is going. Please see para 4 of my compliance affidavit for 1 second.
Yes.
And please, I would invite your lordship to say, your lordships accept this. We have given the figures, Marat. There is no mismatch, there is nothing of the sort. The total, if your lordship sees the table.
Will not go into all that. I mean,
No, I have to convince my lord I have complied with the order. I'm just saying.
It's a compliance affidavit. It's a compliance affidavit of your chairman and managing director. We have accepted that.
Please say your lordships have accepted our compliance affidavit. That will put an end to all this.
By the Judgment of this court dated 15 February 2024, comma. This court directed, into inverted commas, this court directed, into inverted commas, the disclosure of information on contributions received by political parties under the electoral bond scheme to give logical and complete effect, into inverted commas, complete, to the ruling. Full stop. Thereafter, in paragraph 219, this court issued operative directions. Of these directions, in subparagraph B and C are in two parts. Full stop. Subpara B requires SBI to submit details of the electoral bonds purchased since the interim order dated 12 April 2019, into inverted commas, till date to the ECI, into inverted commas, complete. Such details, the court has indicated, into inverted commas, shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased, into inverted commas, complete. In the second part of the operative direction, in subpara C, SBI was required to submit, into inverted commas, the details of political parties which have received contributions to electoral bonds, into inverted commas, complete, since the interim order dated 12 April 2019 till date to ECI. Full stop. SBI was required to disclose details of each, underline each electoral bond encashed by political parties, and to include inclusive of the date of encashment and the denomination of the electoral bond. Full stop. The above narration and the plain reading of paragraph 219 of the judgment dated 15 February 2024 indicates that SBI was required to submit all details, both in terms of the purchase and in terms of the receipt of contributions. Full stop. The expression, to invert commas, include in both subparagraphs B and C clearly demonstrate that the inclusive part was regarded as illustrative and not exhaustive of the nature of the disclosure which was to be made by SBI. Full stop. In other words, we now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include would comprehend the alphanumeric number of, and the serial number, if any, of the bonds which were purchased and redeemed. Full stop. The application, this was on your application, I think you had moved this, no? The application was by the Oh yeah, we had therefore. Mr. Harish Salve, Learned Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date Daldo.
But we have one more day, Thursday.
Stating, yes, certainly, 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
To the Election Commission.
In terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the Election Commission.
The Election Commission shall upload the details forthwith on the communication by SBI.
Obliged to.
My lord, I had directed my lord, the senior official of the bank to remain present. My lord, the deputy managing director and chief general manager are present here. The presence they both are.
Okay.